So you got a letter from your prior employer accusing you of stealing their trade secrets, soliciting their customers, or violating your other post-employment obligations? Or maybe you're anticipating a letter like that. Don't panic. The key is to resist the urge to look at any materials that you may have that relate to your former employment until you have a plan. In this training, I'll provide you with that plan and guide you through the steps to take and those to avoid when you receive one of those letters. Welcome to the 10-minute Trade Secret Training Series, The Entrance Plan, preparing for the Cease and Desist Letter at your new job. My name is Russell Beck. I'm a trade secret, restrictive covenant, and employee mobility lawyer at the law firm Beck, Riden. But although I am a lawyer, please understand that I am not your lawyer, and this is not legal advice. If you feel you need legal advice, or if any of the issues that I discussed today raise any concerns for you, you should speak with a lawyer to obtain proper legal guidance based on your particular circumstances. In today's training, we'll be talking about cease and desist letters, the so-called lawyer letter or demand letter, or sometimes even called a nastygram. But whatever the name, they typically convey three core messages. First, they claim that you're doing something wrong. Often, that's that you're working in a role that you shouldn't be working in, and in so doing, you're misusing or posing an imminent threat of misusing the company's trade secrets, confidential information, or relationships with customers or employees. If you want to learn what trade secrets are, click in the link in the description below. Second, the letter demands that you immediately stop whatever it is they claim that you're doing but shouldn't be. And third, the letter emphasizes that you have an obligation to preserve all relevant evidence. Although cease and desist letters can be quite intimidating, if handled properly, they often open the door to discussing a possible resolution. But unless and until you're able to actually resolve all the issues, there are important steps to take and critical steps to avoid. Most importantly, once you receive a cease and desist letter, you have an immediate obligation to preserve all materials that could relate to the claimed misconduct or the potential dispute. Most commonly, these include Word documents, Excel files, PowerPoint slide decks, records from Salesforce, emails, texts, voicemail messages, and messages in WhatsApp, Slack, Signal, WeChat, Viper, Snapchat, Clubhouse, Discord, and other messaging platforms. But really, any material on any device or platform, whether physical or electronic, whether stored locally or online, that relates to your former employment or potentially even your new employment, needs to be immediately preserved. The failure to preserve documents can have serious consequences, including making the difference between winning and losing a case, as well as having to pay your former employer's legal fees. And that can result just from not even turning off the auto-delete feature for things like emails, texts, messaging apps, and other services. But really, the biggest problem that I see far too often is that the first thing people do when they receive a cease and desist letter is to check to see what documents they have. And sometimes they even think it's a good idea to delete them. Those are both very bad ideas. Let me give you an example of why. Opening a document can alter its metadata. That's the information that shows when the document was created, when it was viewed, and when it was modified, among other things. By opening a document, even just to see what it is, you've just potentially created several significant problems. First, you probably created evidence that makes it look like you were using the document much later than you actually were, and worse, that you were using information in the document for your new job. Second, you've potentially eliminated exculpatory evidence, meaning evidence that would have helped to prove that you didn't use the information for your new job. And third, you will have altered the metadata, which may be seen by a court as something called spoliation, which means the destruction or alteration of evidence. Destroying or altering evidence is illegal, and it can lead a court to assume that you engaged in misconduct even when you didn't. And that can turn a winning case into a losing one with all the negative consequences that flow from that. So when you get a cease and desist letter, resist the impulse to see what you have. Put down your cell phone, put down your iPad, and close your computer. Don't sift through emails or texts or Slack messages or anything else. Don't insert thumb drives or other USB devices into your computer to see what's on them, and don't connect to Dropbox, Backblaze, Carbonite, Commvault, Google Drive, Microsoft OneDrive, or any other document backup or storage site. And don't alter or delete information on your social media accounts. Also, even with physical documents, you'll want to avoid reviewing their contents, as doing so may remind you of confidential information that you may have forgotten, or even provide you with confidential information that you hadn't previously known. Finally, don't reach out to your former employer or any other former colleagues to discuss the letter. Instead, before doing anything else, just review the letter promptly, calmly, and thoroughly. Pay attention to every detail, including any attachments, which will typically be agreements you signed with your former employer setting out your post-employment obligations. Take note of what the letter claims you did, and think about whether the accusations are true. If they're not true, you'll want to think about how you'll be able to prove that. And if some of the allegations are true, you'll want to think about whether there were legitimate reasons for your actions. Also, you'll need to quickly determine whether the letter demands that you take some action, and if so, by when. Sometimes these types of letters don't require a response. In those circumstances, they're often intended just to serve as a warning, notifying you that your former employer has some concerns and they'll be monitoring your behavior going forward. And if it is just a warning letter, your primary focus likely should be on complying with any and all of your post-employment obligations. But keep in mind that the letter may be a placeholder while your former employer investigates further. And if there has been any misconduct, you can expect that the matter will be escalated relatively quickly. But regardless of whether the letter includes a demand for action or is just a warning, your next step should generally be to consult a lawyer. Quickly. Cease and desist letters usually come with very short deadlines, and even when there isn't a deadline, there may be more to come. So you want to make sure that you're conducting yourself appropriately and that you're prepared if and when the next shoe drops. Once you've retained a lawyer, they'll need to review the letter, all attachments, and any agreements with your former employer that were not attached to the letter, especially if they contain post-employment obligations. You can coordinate with your lawyer about how best to access those documents, but you should think about what agreements and post-employment obligations you have. They're often in places that may not be obvious, so it's important to think broadly. For example, you may have an offer letter from when you started your job or when you received a promotion. Maybe you have a standalone employment agreement or maybe a restrictive covenant agreement. Those are sometimes called key employee agreements, information protection agreements, confidentiality agreements, or fair competition agreements. But they can go by lots of different names, so you want to look for anything similar. And there are lots of other documents in which you might find your obligations. Maybe there were comp plan changes that you needed to sign, or what about long-term incentive awards or other incentive compensation plans? Have you received options, restricted stock units or RSUs, performance shares or other equity awards? Each of those is typically governed by a plan that frequently contains some type of restrictive covenants. But whatever the form, you'll want to make sure that you've identified all of them. It's also important to recognize that issues created by cease and desist letters typically involve not just you and your former employer, but your new employer as well. Early on, you'll need to decide whether, when, and what to discuss with your new employer and consider if a coordinated response is appropriate. Your interests will usually be aligned with your new employer, but that's not always the case. And these situations can impact your new employment, so it's critical to evaluate them carefully. Your lawyer can help you navigate these issues, although it may be necessary or advisable to inform your new employer about the letter even before retaining counsel. That might be because there's a need for immediate action, or because the demand involves the new employer directly or requires access to resources or support, or simply because of the need for transparency to help maintain trust with your new employer. In that regard, bear in mind that your new employer may have received a similar letter, and being transparent can be critical to your relationship. Now, while you're in the process of assessing the situation and working on a strategy for responding to the cease and desist letter, it's typically important to maintain discretion. Don't trash talk your former employer or discuss the issues with anyone, other than your lawyer, of course. Doing so will make those people potential witnesses, and anything you say to them can be used against you in court. Also, it's generally best to avoid responding to the letter until you've consulted with a lawyer and the lawyer has had a chance to advise you. Now, if it turns out that you can't speak with a lawyer before the deadline, you may want to notify the sender that you're in the process of retaining a lawyer. This will show them that you're not ignoring the letter and that you're taking the matter seriously, but be prepared. It may lead to follow-up questions from the sender. As I mentioned earlier, a very common outcome in these situations is a negotiated resolution. Very often that involves negotiations between the two companies. If you've been a good leaver, see the link to the exit plan video in the description below, and you've started your new job the right way, see the link to the video about that in the description below, and you follow the directions in this training, you'll be putting yourself and your new employer in a strong negotiating position. In contrast, if you've taken information on your way out the door, used information at your new job, violated your post-employment obligations, or deleted or altered documents or metadata after you learned that litigation is possible, you likely will have unnecessarily put yourself and your new employer in a much more difficult position. So I'll end with a few takeaways. Be prepared for the cease and desist letter. When you receive it, document preservation will be paramount. Make sure that you preserve all relevant documents and metadata meticulously and that you don't alter any of the documents or metadata. And if you've already received a cease and desist letter and looked at some or all of the materials, stop now. The key is just not to panic, but to simply stop and affirmatively think about the issues raised by the letter and the guidance in this video before you do anything that may create more serious problems. Thank you for your time and attention.